Welcome to the Discipline Subcommittee meeting of the California Paraprofessional Program Working Group. I can take roll. Bashan, I understand, is not available today. Falmouth?
Here.
Kirkmeyer, we've been advised, is going to be joining us late. Spyro?
Here.
Great, thank you.
Okay, and does it look like we have anyone for comment, Linda?
There's one attendee, so with the initials NA. If you're interested in making public comment, please raise your hand using that Zoom function. I don't see a raised hand, so perhaps we can go ahead and get started.
All right. So I only got one slide here. What I tried to do is just outline what I think are the remaining issues for this subcommittee. So let's take a moment here and see if these reflect your understanding as well. Regarding the first one, I will say that we had some discussion about this yesterday in the family law subcommittee meeting, the need to generate, or the desire to generate, recommendations with respect to enhancements to the existing UPL sort of infrastructure system. And so I think maybe we'll consider a format for doing that jointly, either with that subcommittee or maybe put this on the agenda for a full working group meeting to kind of brainstorm what's coming up across the various subcommittees with respect to UPL. Other than that, anything that you think is missing or that you think is actually fully resolved?
This is Julie. Excuse me. Remind me again what we need to do in the UPL area other than modify existing statutes to allow paraprofessionals to practice legally in their area of specialty.
No, I don't think it's anything that we need to do with respect to the implementation of this program. However, you all heard from, I think, the LA County DA and
Yes.
the internal OCTC unit, and there were certainly recommendations made about improvements that are needed generally to either funding for our OCTC program or certainly for the DA's offices. There was a recommendation that came through from that DA about a statutory change to make these felonies as opposed to misdemeanors.
Okay.
But really, it's if this group and the working group more broadly want to consider coming up with those types of recommendations as part of the final report.
Thank you. I remember now. It's been a long holiday.
Okay, so I think that this is our list, and I think today, my understanding is that you will want to focus on the public records issue. I mean, we can get through as many of these as we can, but do you want to start there?
Sure.
Okay. So Linda, can you start off by just reminding us how this works on the attorney side?
Yes. So, so in terms of complaints against attorneys, they are not public until a notice of disciplinary charges is filed. So once that's filed, then everything becomes public in terms of the NDC and any actions that's taken afterwards. And then in some circumstances, if there's a stipulated discipline and that happens prior to the NDC being filed, then once the stipulated discipline order is entered, then it becomes public. And my understanding is there's not a limit to the length of time that these records are public.
Well,
And the other thing I want to clarify is that everything is public with the exception of a private reproval. So a public reproval and anything which doesn't have to go to this Supreme Court, a public reproval is becomes public, and any orders by the Supreme Court are public. So any discipline that's beyond reproval, and a private reproval may also become a public record if it's that's the discipline that's ultimately imposed after an NDC is filed. So if an NDC is filed and ultimately what happens is a private reproval, then the private reproval is public.
Say that again?
So in general, a
About the
private
private.
reproval is not public, but if an NDC was filed, then that makes the whole thing a public record.
No, NDC is notice of charges.
Right, a notice of disciplinary charges. And so if once the NDC is filed, then it becomes public. And so even if the ultimate discipline that's imposed is a private reproval, if that's subsequent to the NDC, then that private reproval becomes part of the public record.
Is that in a statute or a regulation anywhere?
It should be in state bar rules.
Okay, here's a question that I have. If an NDC is filed and there is a great deal of negotiation going on between the attorney and the Office of Chief Trial Counsel, and can the parties agree to a private reproval that is not made public?
I don't think so, only because since the record has been made public by virtue of the NDC, once the NDC is filed, the whole thing becomes public. And so I think since that happens, then there needs to be some resolution that's made public.
Right.
Otherwise, it's just sort of left there as if it were an completely unresolved matter.
I've just looked it up because I thought that's a good question.
Thank you.
According to this reported, so a private reproval is not a matter of public record unless imposed after the initiation of formal disciplinary proceedings. And that is a state bar rule of procedure 5.27D. And just to backtrack, the source of the requirement that disciplinary proceedings are not public record prior to the notice of disciplinary charges, that the source of that is the State Bar Act.
Say that again.
The State Bar Act requires that all disciplinary proceedings prior to the initiation of a notice of disciplinary charges remain confidential.
Oh,
So, but I think, Julie, you were asking a slightly different question, which was, I think, could the parties stipulate in the instance where there had been a private reproval, then an NDC was filed, thereby making the private reproval public, but through negotiation, some kind of settlement process, could the parties stipulate that private reproval would then again become private? Is that what you were saying, Julie?
No, what I was saying was, if the NDC is filed and then there's a great deal of negotiation and the parties agree to stipulate it down to a private reproval, is the Office of Chief Trial Counsel allowed to agree to not make that public as a part of the stipulation? But I think Linda's probably right that once an NDC is filed, the result of anything that results from the NDC has to be made public as well. And Greg, I'm remembering from many, many, many years ago, an old rule or law that allowed the state bar president, if there was an investigation going on of some matter of great public risk like embezzlement from a client's trust account, or that the state bar president could authorize the, not necessarily running out and having a press conference, but the disclosure of a pending investigation prior to the filing of the notice of disciplinary charges. Does that still exist?
I don't believe so. I mean,
Okay.
I would think that the State Bar Act provision trumps any authority that the now executive director, it used to be well, I guess you have the president of the
Board
board,
chair,
would
yeah.
probably be the executive director at this point. I
Okay.
think that trumps any ability for the state bar to make a proceeding public, because they're under statutory constraint to.
Actually, I'm just looking at 6086.1, and it looks like there is an exception for the confidentiality requirement. It says, this is the State Bar Act 6086.1B, which says all disciplinary investigations are confidential until the time that formal charges are filed. But then it says this confidentiality requirement may be waived under any of the following exceptions. The licensee can waive it, or the chief trial counsel or chair of the state bar may waive confidentiality, but only when warranted for protection of the public. Under those circumstances, after private notice to the licensee, the chief trial counsel or chair of the state bar may issue, if appropriate, one or more public announcements or make information public confirming the fact of an investigation or proceeding, clarifying the procedural aspects and current status, and defending the right of the licensee to a fair hearing.
That must be what you're referring to then.
Yeah, it is what I'm referring to.
Yeah, didn't we do that with Avenatti?
I think that there are a number of times, sometimes when you look, if you look at someone's, their attorney profile on the public site, there's a big red banner, warning banner at the top,
Right.
saying that there's an investigation pending, that discipline hasn't been imposed, but that there is an investigation pending. So we do that.
Is that done always when there's an investigation pending?
No, I think it's just in those circumstances when there's a risk to the public, that we want to warn people, because I mean, that proceedings are still in process, but that there may be a risk. And it's a big red banner across the top.
Yeah, I think there's a state bar rule about consumer alerts.
Yeah, that's what it's called. Yes.
Yeah.
The one other thing I would mention is that, the complainants have an opportunity to file an accusation with the court if they're not satisfied with the disposition of a complaint that they've made against an attorney. And very often that would be that they didn't file disciplinary charges against the attorney. And the court is not constrained under the State Bar Act, because these are court records. So once they file a Walker petition with the court, that becomes a matter of public record through the court.
What's a Walker petition?
A Walker petition is based on a case from, I think, the 1950s that really, it opened up an avenue for complainants who have filed a complaint against an attorney, and OCTC, in its prosecutorial discretion, decide not to proceed either with an investigation or have completed an investigation, have chosen not to file charges. The complainant can appeal that decision directly to the Supreme Court. And we get every conference, we have at least 5 or 6 Walker petitions that we're dealing with. It's rare that the court will send it back. I think, Leah, you alluded to the fact that it's probably 1 or 2 per year, but it does, on occasion, they are sent back.
And I just want to clarify, they're required to exhaust the state bar's process. So before they can file the petition with the Supreme Court, they have to make a request to our complaint review unit, which is in our Office of General Counsel. It used to be within the Office of Chief Trial Counsel. The complaint review unit now is in the Office of General Counsel. So if they aren't satisfied with a decision made by OCTC, they can request this review by the complaint review unit. And it's only after the complaint review unit affirms the decision of OCTC, then they can file a petition. If they file a petition with the Supreme Court prior to doing the complaint review unit step, the Supreme Court rejects it.
Yeah, that exhaustion requirement is one that the court imposes on the complainants.
Right. And sometimes there have been 0. I think that there's been 0 to 2 from of the Walker petitions where the court has sent it back for many years.
I think since I've been with the court 2013, I can think of 3 right now, but.
Yeah.
Well, just more generally, rather than down in the weeds where we've been messing for the last few minutes, I don't see any reason why the publication of disciplinary matters should be different for paraprofessionals than they are for lawyers. There's no, that nothing comes to mind as to why they should be different. I would point out that, and I wish Kim were here, this framework that applies to lawyers is generally consistent with the public disclosure policies of the agencies within the Department of Consumer Affairs. The only thing that varies, and it's sometimes board by board, is how long should these records remain public. The medical board recently adopted a rule, or maybe it's just even in a statute, that medical board disciplinary actions, formal actions, should be posted on the board's website indefinitely, i.e. forever. And there are like 2 or 3 other categories. Felony convictions, I believe, is one. And I forget the others, but there are several categories of records that the medical board has formally decided should be posted indefinitely. Other boards in the Department of Consumer Affairs, it's kind of hit and miss. Citation and fine is a remedy that the DCA boards have that the bar apparently does not have. I didn't even know that. Those are generally published for no more than 5 years. And at some boards, they're published for 3. Diversion is as I tried to explain at a prior meeting, diversion is a term that in the Department of Consumer Affairs means a complaint has been made based on substance abuse, and the licensee has been, quote unquote, diverted out of the disciplinary system and into a substance abuse program. Those records are generally not published on any board's website at the Department of Consumer Affairs. But Ira was talking about a different kind of diversion at an earlier meeting of this group, more on the criminal side. So we kind of need to decide what that term means in this on this chart.
So it sounds like, Julie, your policy recommendation is to align with the current structure in place for attorneys with respect to what is made public and when, but for the how long is it made public, which we don't believe there are any limitations right now in place on the attorney side. You're recommending that perhaps we look to various DCA boards, the medical board is an obvious parallel, to perhaps establish some time limits on how long things are made public?
Only on the citation and fine and the lower level disciplinary actions. I would publish formal discipline actions indefinitely. I wouldn't make it any different for lawyers. I mean, for paraprofessionals than what applies to the lawyers.
In terms of those time limits on citations and fines for other boards under the Department of Consumer Affairs, is the source of that is the source of that restriction statutory?
There is a statute. It's Business and Professions Code section 125.9. And it allows boards and commissions and bureaus in the Department of Consumer Affairs to establish a citation and fine system for low-level violations, which don't merit the full expenditure of resources needed to conduct a formal, full-blown disciplinary action, but nevertheless are violations of law and should not be ignored. So a citation is like a ticket. It says it's like a cease and desist order. Cut it out, stop it. Under the statute, a citation can be accompanied by a fine And the fine is currently, it looks like $5,000. It shall not exceed $5,000 per violation. If a board in the Department of Consumer Affairs wants to have a citation and fine system, they have to adopt a set of regulations formally pursuant to the Administrative Procedure Act that governs the process by which these citations and fines are issued and how they can, how they have to be, how the licensee has to be notified, how they can be appealed, who they can be appealed to. And generally within those regulations that each board individually adopts, they will put something in there about how long a citation and fine should be disclosed on that board's website. So that's how it, but
And I
it's,
imagine those statutes and those and the authorization to promulgate regulations for each of those boards that want to institute that type of system, they act as a statutory exception to the general requirement to disclose public records under the California Public Records Act. And the reason I'm asking is it seems to me that we would probably have to have some sort of statutory enactment for paraprofessionals as well, because as you know, the State Bar is now subject to the California Public Records Act as well. And
right.
the provision that Brady just read out is an exception to the general requirement that these public records be disclosed. And I remember there had to be some amendment to not just the State Bar Act, but several provisions to make sure that it was going to be read that way. So I think in this area, this is not something that the court wouldn't have the authority really at this point to carve out exceptions for confidentiality of records, even if we stand up this new licensing scheme. I mean, so in short, I don't think we can avoid legislative involvement.
Do you mean, Greg, the Public Records Act would be implicated by imposing some kind of time limit on how long the record is public? That's what, so it would be public for 5 years and then it would not be public anymore.
Well, no, what I mean is, so if we look at the attorney system, we were just talking about the confidentiality of disciplinary proceedings prior to the institution of a notice of disciplinary charges. That statute is harmonized with the California Public Records Act purposefully. And as it pertains to attorney discipline meted out by the State Bar, if we're going to create a new licensed professional that is going to be administered by the State Bar, so the licensing authority is the State Bar, there needs to be some statutory changes. Otherwise, someone would have a very colorable argument that all disciplinary proceedings of paraprofessionals, even prior to the institution of a notice of disciplinary charges, should be open to the public unless the legislature acts to protect those records.
Okay.
Yeah, I actually talked to Suzanne about this, and she said, we always assert the, and I'm not a CPRA expert, but there is the balancing test. If we asserted that that the public interest is served by keeping them confidential, baseless complaints or something like that. But I agree, it's not a clean solution unless there was a actual exemption to the CPRA to create the confidentiality.
Right.
And then there's another kind of policy issue, which is it's one thing to say something's public or not public, and it's another thing to put it on our website and put it like in red letters in bold all over the website, because something could be public pursuant to a request, which is very different than affirmatively putting it on the site. And that's something we just decide.
Mm-hmm.
And you're right. That's exactly right. That's what I was just going to say. I was interpreting public records on this slide as meaning, what do we post on our web? What does the bar post on its website? But Greg and Brady are right. That's public records means the Public Records Act. And I will further confuse the matter by telling you that the medical board has 2 statutes. One is Business and Professions Code section 803.1, which says what is a public record at the medical board in terms of the disciplinary process. And 2, what the Business and Professions Code section 2027 says which of those things that are public records on the in 803.1 shall be posted on the medical board's website. So there's two different statutes. And so it's very possible that something is a public record under 803, but it's not, it's no longer or never was posted on the medical board's website.
Mhm.
Really, are the Department of Consumer Affairs agencies covered by the Public Records Act?
Yes. Oh, yes, all of them. Yes.
I like that approach because it's really clean. It's with the state board, we've kind of gotten there by formalizing the whole review of what is on the website. But so there could be two different sets of recommendations coming out of this group. What's going to be a public record, and that could align with what's public on the attorney discipline side, and what's going to be on the website, and that could align on the attorney discipline side. Again, with what's on the attorney discipline side, I just think the only difference is this issue of, well, we don't have citations and fines on the attorney side. The diversion is the agreement, alternative in lieu of discipline maybe is the diversion. But then there is no time limitation for any of these things being on the website even. So that would be, you know, a new recommendation to come up with.
And I think one of the things that was discussed that Kim had talked about in terms of what's public and what's not is just a matter of whether there's a finding of a violation. So with this, with both formal discipline and a citation and fine requires a finding of a violation, whereas diversion doesn't necessarily come from the finding of a violation. And so if there's no violation found, then there's not a reason to make that record public.
I have a feeling, thought last several minutes and before today also that maybe we can make some specific recommendations right here, decide on them in order to speed things up. Because there's a lot of the meetings, I've tried to go to all of them, a lot of cans keep getting kicked down the road. So maybe we can make some recommendations. For instance, my thought right now, Julie knows a lot more about this. I think all of you know.
Kim is
more
here.
about this.
Hi, Kim. We've been
Hi, sorry I'm late.
missing you.
Oh, hi.
I just saw you when I stopped screen sharing.
I just jumped in, sorry.
Okay, sorry, Ira.
Sorry. Anyway, I have disagreements with some of the things that are done as far as in the attorney system, as far as what's public, what's on the website. But I think Julie's right that we shouldn't make it different, make the paraprofessionals different from the attorneys. So that's one point I'd propose for a decision today, that we make it the same. Now, it can't be the same for two things that the attorneys don't have, the citation and fine and the diversion. So I think we ought to have the citation and fine be public and on the website, and the diversion neither. And I would propose that we put a 5-year limit on how long the citation and fine be public and be on the website.
Okay. So the only thing that is not public is what is a public record? These two. So what's not public, it would be diversion.
Yeah.
Also complaints and investigations generally,
Oh, yeah.
subject to the statute that Brady read.
Mhm. Subject to statutory exception.
Can I ask a question of Ira on the citation and fine with the 5-year limit? Usually you have to have a date that's from. Would that basically be from the date of resolution which could be like payment and meeting the order of abatement if there is one.
You mean, say that again, what were those two things?
So usually for like a date, you want to have it like when the 5 years runs from. And so like it could be from like the resolution of the citation and fine. And resolution can mean like the payment of the fine if it's just a fine that's been issued. But a lot of times with the citation and fine, there's an order of abatement, which means they have to do something. I mean, I don't know what we'll be issuing a citation and fine on, that everything would have an order of abatement. But if it did, then it could be 5 years from meeting both of those.
What kind of orders of abatement? Can you give us an example?
Yeah, so I'm trying to think if this would even pertain to an attorney, but for us, for medical board, for example, when we would issue a citation and fine, maybe it would be for not providing a patient their medical records, or for not providing the board their medical records, or not completing their CME or things like that. So their order of abatement was that you'd have to give the patient their medical records. You have to give the board their medical records. And then once they did that, it was completed in that regard, but you still had to pay the fine as well.
Mm-hmm.
Well, the way I was thinking of it was the 5 years would be from the issuance of the citation.
Even if they never pay it?
Yeah, because I imagine there'd be additional proceedings against them if they don't pay it, and those could be public.
I don't know if you'll be using citation and fine for unlicensed activity, but it does, sometimes it's a nice thing because, DAs might not do a lot on some of these at the first point. The only thing is if it was for unlicensed activity, the nice thing is you have that out on your website for a longer amount of time. If it's for unlicensed, if you do it with, when they meet or pay the citation, because those are kind of sometimes hard to get the individual to pay for because you don't have any further action you can take on them.
All right. Well, how about if it were, I'm changing my mind, 5 years or when they fulfill the requirements of the citation and fine, whichever is later.
Does anyone have an issue with that?
So you're saying if they pay it, then it's over, or 5 years from when they pay it? This is what's not clear to me.
It's 5 years from the issuance of the citation, or when they pay it, whichever is later. So in other words, it's not 5 years from the payment.
I see.
5 years that's extended if they don't pay it. I don't know how the abatement order fits in here, though.
Well, I think it's what she said, like if it's, you've got to return the client file in our
Yeah.
context.
Or like for false advertising, stop it, cut it out.
What's that's a weird term in my mind right now. What gets abated?
The violation. So 125.9, which is the Business and Professions Code section setting forth this whole citation and fine business. 125.9B says, well, A says, if you want to do this, board, you have to adopt regulations, a regulatory system. In regulations adopted pursuant to the APA, which is a public process. Sub B says the system shall contain the following provisions. 1, citations shall be in writing and shall describe with particularity the nature of the violation, including specific reference to the provision of law determined to have been violated. 2, whenever appropriate, the citation shall contain an order of abatement fixing a reasonable time for abatement of the violation.
Oh, abatement of the violation. Okay.
Right. So you may have a one-shot violation, which is done over and you get a citation and fine for having committed it. But if it's an ongoing thing, they will include an order of abatement in the citation.
Oh, all right. Well, so I don't think that it reads, what I think it ought to read here then is 5 years, or when the fine is paid and the conduct abated, whichever is later. The violation abated, whichever is later. It's not from the abatement order, I think.
No, I said it with the abatement order was satisfied.
Oh,
Plus violation abated, is that what you said?
yeah. Yeah. I mean, I was thinking abatement order is an abatement of the proceedings, which is not, so be a little, makes it clear to me anyway. I guess,
Does this look good?
yeah, maybe we need a, sorry, but an A in front of the 5 years and a B after the or. Because there's 3 things there really. Make it clear what the 2 things are.
5 years, or when fine is paid plus violation abated if applicable.
Yeah, so somebody doesn't get confused saying, well, is this, what's the late, they don't think there's 3 things that. could-
Okay, well, let me work on cleaning this up. I don't, I get it. Okay.
Yeah, okay,
Mhm.
there we are. Yeah.
Julie, since Kim is here, is there anything you wanted to ask about DCA?
Kim, what I was saying before you got here was that if a DCA board or bureau wants to create a citation and fine system, they have to follow 125.9, which requires them to adopt regulations. And the statute contains specific items that have to be contained in the regulations. And sometimes those boards will include in their regulations the time limit for public disclosure on the board's website of that citation and fine. And that can vary from board to board. Is that correct?
That is correct. Yes.
Okay.
Yeah.
At the Med Board, I think it used to be 5 years, but I'm recalling that you said at a prior meeting of this group that it's now 3.
It is 3. It's when we were able to get back that we could add those old, probations and things like that. The
Yeah.
10-year, when we got rid of the 10-year rule,
Yeah.
that was something we had to give up, as that citation and fines went to 3 years.
What
Okay.
was the 10-year rule, Kim?
So the 10-year, it's still, yeah, this was, it was funny because it was 2003 that it passed. And I was always like, I have to be out of here by 2013 because that's when this is going to really come into play. It didn't happen. I was still there. So we had to live through it. But every disciplinary action at that point under this law, every disciplinary action after 10 years from 2003, basically, and then for anything older and then anything from 2003, and then going forward, 10 years, it had to be removed from the board's website.
Mm.
So like if an individual was revoked, you could keep the current status of revocation, but everything else had to come off. And if a person was on probation, that would come off. You'd never know that that individual was ever on probation. And so we thought, we tried for a couple years to get that overturned, that law. And finally, I can't remember what year we finally were able to, I think like 2015, maybe, Julie. So we took off like tens of thousands of records in 2013 when it hit. And then we were able to get the law changed. So what it is now is like probation and revocation, those egregious issues, those continue on. But public letters of reprimand and public reprimand, those still come off in 10 years. But everything else now continues indefinitely. But it was quite an endeavor to take it off, and then quite an endeavor to put it back on when it went through. And there were other things too, like, you know, for us, we also post malpractice information on licensees. So it's, you know, if you have a settlement and it meets certain requirements, or if you have a judgment or arbitration award, those also came off, and then they went back on. Those were 10 years. The only thing that stayed on the record was if a hospital had taken disciplinary action against an individual, or if they had a felony conviction. Everything else ran into that 10-year rule. And there are some boards who have looked at this. This is a mixed bag as well, like how long some boards want to implement policies like that. And obviously we kind of discourage them from that because we think it's important for the public to make informed decisions, but it is kind of different depending on the board.
So in picking 5 years, Ira, are you doing that? What is the rationale? Like, should we see what the average is for DCA board? Should we align ourselves to the medical board? Would we say, even though the medical board recently moved this down to 3 years, we don't think that's the right public policy, so we're making it 5?
No, not now that I hear that it's 3, I'd say 3. I mean, these are doctors we're talking about. So if it's good enough for them, it's good enough for the paraprofessionals, in my opinion.
Kim or Julie, any?
No, I don't care.
Me either.
All right.
I mean, I like the 5. I have to say, we like the 5, but
Yeah.
and it was definitely a bargaining tool we used to drop it down. But I don't think it really matters. It's such a deterrent for the individual to have that citation record online. Period. That it is helpful to have it as a public record.
So Kim, I was also telling them before you got on that the medical board has 2 different statutes. 803.1 says what kind of disciplinary matters are public records under the Public Records Act. And 2027 says which of those must the board post on its website and for how long. So even if if the bar adopted a 3-year time limit on the posting of citations and fines for paraprofessionals, even after that thing comes off the bar's website, it's still a public record under the Public Records Act.
So when we did our regulations, for citation and fine only, for others it was different, but for citation and fine, once it gets purged, it gets purged for citation and fine. So it doesn't continue to be a public record just for that category.
Okay.
And
But like the public, oh, sorry.
Is that what you all are recommending here? Because that's what I have been thinking but I realize now it's not clarified. Are you thinking this is just coming off the website in 3 years, or it's not public anymore?
Not public and off the website. That's what I'm thinking.
And if it's not public, then you should probably purge it. It makes your Public Records Act requests and everything. And that's why you have to have it in your regulations, that's part of it as well. It gets purged. One other thing too, we do have is that for a citation and fine that is subsequently withdrawn as part of like an informal conference, if it's withdrawn, then we also remove it as well. I mean, that's probably something in the writing of the regulations more so, but I don't know if you want to consider that, in this discussion.
Well, if it's withdrawn, it would seem like the charging prosecutor person at the med board or the board decided it either wasn't committed or it wasn't a violation, so it shouldn't be public.
But it was public initially. What's the point at which they're made public? Kim, as soon as it's
So-
issued?
So this changed as well. It used to be that as soon as they were issued, it would become public. And then when we had this change again, I think in 2015, it changed to it was public 30 days after the issuance if an appeal had not been filed. So if an individual appeals the citation in 30 days, it doesn't go on until it basically gets upheld at that point. So it's a little bit different. For me, if you're doing this, I would just say at issuance, it becomes public.
Well, these are, the citations are done unilaterally, right? By whoever the disciplining authority, and without a chance at opposition by the professional, as opposed to all other types of discipline, right? So it bothers me that it would become public right away without the person getting to challenge it. So yeah, I would say it should be delayed at least 30 days. And then I take it that provide the rules provide that it's delayed while the appeal's pending, right?
Yeah, I can grab that language real quick.
And right now we have the appeal, OCTC having the authority to issue these, right? I'm thinking about the flow chart, Linda. And then if somebody wants to appeal it, it goes to who?
You want me to bring up the flow chart?
Yeah, sure.
Let me find that.
Yeah, it's funny, Lee. I was wondering that same thing. I don't know that we identified. I was looking at the flow chart. I don't know that we identified who the appeal is going to.
All right, just
At DCA boards, is the citation initially issued by, for example, the enforcement chief? And then if the licensee wants to appeal it, they would get an informal conference or a hearing, or not an APA hearing, not with a judge present, but just an opportunity to talk to the executive officer. Is that how it works?
Yes, I'd have to check with some of the other boards because it used to be like that for us. And then we changed it to where it's the executive, director or their designee. I think in our regs, we changed it.
Right.
So basically you could have the same executive officer, the enforcement chief who reissued it could also be the same one that sits in on that informal conference.
Okay, so this version of the flow chart doesn't look like it has anything
Right.
coming out.
It
I thought we
doesn't.
had another version where we did.
this is the one that was included at the December meeting.
Yeah, I think it was in an earlier version.
Right.
For us too, we have 2 appeals that they can do. They can appeal it to, like Julie said, for the informal conference, or they can also take it to the Office of Administrative Hearings for a formal hearing.
Yeah, that's true.
Or both. They can do both too, or one and then the other.
And that means getting an administrative law judge, which is kind of like your hearing judges, to preside over an evidentiary hearing on, whether the violation occurred, whether the citation and fine is appropriate for that, whatever the licensee wants to argue.
So it sounds like if we were going to have a parallel structure, whatever the attorney is in OCTC issues a citation and fine. I'm the paraprofessional. I don't agree with it. I can, or if we wanted to replicate the DCA process, I would be able to file a request for review or reconsideration within the Office of the Chief Child Counsel, maybe the Chief Child Counsel. Then I would also be able to request that the hearing panel, I think that's the body, would review my appeal essentially. And would it be a requirement that you exhaust the internal administrative remedy before you go over to the hearing panel, or you can choose to do either one?
When
So-
you say hearing panel, Leah, are you referring to one of the hearing panels on this chart in the green boxes? You're not referring to the State Bar Court hearing panel.
No, I'm referring to that hearing.
Okay.
So if I could make my own law, which, you know, we can't, but since we can right now, or at least offer it up, I would say you have to exhaust the OCTC first before you get to the hearing panel.
Okay.
Because a lot of, you know, citation and fines are different. And I don't know for you if it would, you know, if for this it would be different, but they're only preponderance of evidence. They're not clear and convincing. And so a lot of times, you know, we'll have the evidence that we think we have, but then when they come in during an informal conference, they'll bring something in that shows that that citation might not have needed to be upheld. And it's a lot easier if it comes in at the point of that lower level appeal than having to go all the way and setting up a hearing for it.
Okay. That makes sense to me.
Sounds good.
All right. Should we talk about diversion? What is it? We talk about having maybe, yeah, if you stop screen sharing, Linda, I will just pull this up again.
What is the status of that LAP program? Is it even still part of the bar? Is it moving over to the nonprofit? Is it disciplinary?
So the program still exists. I think before I left, I was trying to incorporate the disciplinary component, meaning those who are formally part of the discipline system, into the Office of Probation, kind of creating more of a drug court model.
Mm-hmm.
And then where it is not part of the disciplinary system, leaving that to the voluntary LAP. And at that time, you know, the idea was perhaps the voluntary LAP could spin off to CLA. I don't know where things are. I don't know, Linda, if you have any sense from doing the ADR. Yeah, go ahead.
Well, not from the ADR so much as the question is whether this is going to be part of our legislative agenda this year to move LAP to the voluntary part to CLA. And I think that really is, there's some opposition to that from the SEIU. And so there were some changes made and to the voluntary program. And what's happening now is we're undertaking an analysis to see if usage of the program has improved due to the changes that were made. But what we found in surveys that were done is that people didn't want to participate in voluntarily participate in this kind of a program that was part of that was run by the disciplinary authority. Mm-hmm. And so that's where there was this idea of moving it to CLA, where people felt like it's really disconnected, but it's not clear yet if that's going to happen.
Well, even currently, LAP program, by the way, LAPS for Kim and Ira stands for, I think it's Lawyers Assistance Program, and it's a program for substance abusing attorneys. It is referral to that program is often accompanied by something called an agreement in lieu of discipline, which has confounded me for 15 years. But those records aren't public, even as to attorneys in the LAP program, right?
No.
Yeah.
It'd be similar to our prior diversion program, Julie, I think.
Yeah.
Right? Yeah.
Yeah. Yeah. I propose we not talk about this until we learn more about the status of the LAP program, because if it spins off to the nonprofit, it's not going to be a governmental program at all anyway.
Well, I think the plan for the spinoff is limited to the voluntary part.
Yeah, not the
I think the ALD, the diversion part would stay, like Leah said, like within the probation or one of the
Okay.
other.
Okay. Okay.
And I think one question is, Julie, you've said in the DCA side, and Kim, you could confirm this, diversion refers, it sounds like exclusively to matters involving substance use or abuse. Ira, you're bringing in the concept that's a broader concept used in the criminal justice side. Diversion is diversion. Like you have, for example, I could think of somebody who had a trust account violation and it's minor, and the diversion, we diverted you out of the system, but you've got to go complete a class. It's not so different than an agreement in lieu of discipline, frankly. So maybe we should clarify
Yeah.
what we mean by diversion, which I think you raised that at the beginning of this meeting, Julie.
And do you have something like that on the attorney side right now, where they could go take a course and basically do they get out of is it something that would raise all the way to the level of discipline, but you still let them get a course and not have to go through the disciplinary process?
Yeah, I mean, I'm thinking about the agreements in lieu of discipline. Conditions, this is the email on this I got from the Chief Trial Counsel. Conditions are quite similar to what you'd see in a low-level discipline or such as a reproval. So it could have gone that route. Ethics school, client trust accounting school, quarterly reporting requirements. So
Yeah, I struggle with that one because we got away from all of that. It's kind of almost, not that it's not completely black and white, but it's like if it could go to a violation, it goes to discipline, or you get a citation, one of the two. It goes down one path. We don't really divert anybody for anything other than substance abuse. I don't think, at least for DCA, I don't think. We used to do these enforcement agreements way back in the 90s, and it really, at least on the medical board side, I don't know if any of the other boards did that. And it really caused a lot of problems. So, the public part of it, the whole interaction with, there was a violation, but what do you tell the complainant? And we kind of got away from those on our side. And I don't know, Julie, there's no other boards that were doing those that you guys monitor, right?
No, not that I know of. They were foreign to me, and they only came to my attention because Dave Thornton was doing them at the Med Board. Yeah.
but
it sounds like
the conversation, because there's such a conflict, I think, between like this broader movement around the idea that people rehabilitate, that you don't like bring the hammer down for every single thing that people do. It's gotten us into a lot of trouble on the criminal justice side. It's not effective. You have these terrible recidivism rates, huge prison costs. And then here in the professional licensing side, it just seems to be, a different kind of balancing test, looking at the consumer protection. But I don't know, I kind of struggle with it, because I like the idea of giving somebody an opportunity to go to client trust accounting school. You didn't know how to do it, you screwed up, but we're not going to kind of give you a red scarlet letter forever, So I don't know.
I know it is a struggle. And we've gone through where we had like a medication, you know, when I was on the board side, medication error committee, where we looked at, is there a possibility where if it's just one error, it's the only one they've ever had, and we could send them to some kind of training, then maybe they'd be more apt to report those kind of things. And, you know, we didn't really get anywhere with that committee, but I know that this is a whole issue that, you know, communities everywhere are trying to deal with, I think.
But it sounds like your recommendation would be no agreements in lieu of discipline. That you have, if we were doing the DCA model, diversion would be solely for substance abuse cases, and that would be using the mandatory LAP program, Julie, which would stay at the bar regardless.
Mhm.
And then there's citation and fine, which is an option for those lower level matters. And there is a huge benefit there because those under your recommendation will come off of, not be public after a certain period of time. Whereas, you know, a public reproval, if it goes to that level, it would remain public in perpetuity. But those would be the only alternatives.
Our ADP program is for attorneys charged with misconduct, and they've had, the state bar court has identified them having a substance abuse or mental illness problem that was the cause of the misconduct. So I would imagine you want to include that as well if you're going to do an ADP program.
Yeah, ours had mental illness when we had our program as well. But a lot of ours were dual.
Yeah, the statute said the program was for physicians with substance abuse problems or mental illness. The effectiveness of a program on mental illness is dubious because you can't measure mental illness like you can make somebody pee in a cup.
Yeah,
But
and frankly,
it's a different story.
yeah.
But you know what, Leah, what you were saying, it is a struggle. And I'm recalling, Kim, a few years ago, a bill was passed allowing the executive officer to issue either a private or a public reproval, probably a public one, that included you must go to this course. But public reprovals, those are public at the Med Board, right?
Yeah. Mm-hmm. Yeah. If we require a course with the public reprimand, it gets posted on their website. The one thing though that we do though, that Julie, maybe you don't even know about this, but when we would issue a citation for like medical records, like maybe they had egregious medical records. And then if they would go so we'd issue the citation, if they were willing to go take a medical record keeping course, which it wasn't just like a, 3-hour course, it was a 3-day intensive medical record keeping course that had to be by a certain approved provider, we would actually withdraw that citation so that it wouldn't, it was a done deal. We wouldn't make them pay anything. We wouldn't uphold that citation. That's the only thing that I can think is a little bit similar to what we're talking about here.
So that's one of the circumstances under which the citation would be withdrawn.
Yeah.
That you referenced earlier.
Yeah, as well as if we didn't have the evidence.
As far as, I have a question for both the lawyer side and the Department of Consumer Affairs. In the diversions or whatever it's called for substance abuse and mental health, is there a limit on how serious the offense can be to be eligible for those programs? Seems like there should be, but is there? Or was there?
The medical board's diversion program was abolished in 2008. And although there is a statute authorizing the board to recreate a new and different kind of program, they haven't done it yet. Other boards like the dental board, the pharmacy board,
Physician assistant.
diversion programs, they are run by an outside corporation called Maximus. I don't know where I pulled that out. So the department has a master contract with Maximus, which runs diversion programs for 6 or 7 boards in the Department of Consumer Affairs.
There was a defendant I sued in the class action.
Accident?
Wage violations, nothing terrible.
But in terms of the answer to your question, Ira, like, is there an offense that is so horrible that we wouldn't put them in diversion? Instead, we would just discipline them and take away their license? I don't know of any. I mean, I don't know of any statute at any DCA board that has anything like that.
But doesn't I thought we do have it on the.
Yeah, I'm just looking at it right
You
now.
can
So the
shut down-
limitation
Yeah.
on eligibility in the lawyer ADP, disbarment is warranted under the terms of the stipulation. So one of the requirements is they enter into a stipulation of facts and conclusions of law, including the aggravating factors. And if that demonstrates disbarment is warranted, irrespective of the mitigating circumstances, they can't participate.
Oh,
Also, criminal convictions resulting in summary disbarment. So there's certain criminal convictions
mhm.
involving acts of moral turpitude. So they also cannot participate.
And for ours, we actually, if it was involved with any other violation, so if you had anything else that was related with your substance abuse, they could maybe go into the program, but we would continue down the discipline route as well. So, you know, if you had injured a patient and you also it was because of a substance abuse, you couldn't just divert into enforcement just for that. Really, I think the statute for even the diversion program said something that it had to be the only violation that you were looking at.
Mm-hmm.
How does it even come to your attention then? Like, somebody reports that a doctor is drunk at work, but there's no claim that there's been any patient contact during that time, or
It could be any of those.
Yeah, any of them, right?
Yeah, a nurse or somebody who works there, or a spouse, or there's all kinds of ways that cases of substance abuse got reported to the med board.
Yeah.
because I feel like that doesn't happen on the attorney. I feel like it's never like just, oh, this attorney is a drug addict. I feel like it's always associated with this went wrong with this case.
Well, so when somebody is seeking to participate in that program, it's sent to it's a confidential proceeding, but it's sent to what we call an ADP judge. And one of the things that the respondent has to establish is a causal connection between the misconduct and their substance abuse or mental illness. And one of the determinations that need to be made, and it's usually through expert testimony, is whether or not the attorney is going to benefit from participation in the program. So I think this gets to what you were referring to, Julie. If it's clear that even participation in the program may not protect the public from future misconduct by this attorney, then it's not an option for them to participate in the program.
I like that.
Yeah, you're right. And the part about the participant as a condition of getting into the program has to agree to facts and
Conclusions of law.
that never existed at the med board.
Yeah, I have to, frankly, I don't recall ever having to deal with a case like this. So I'm just looking at the rules, but they're under rules of State Bar Rules of Procedure. Looks like 5.384, 382 through 384. So we could look at that procedure.
I will say that the criticism, there are many, but one of it is there's such small numbers of people that go through that program, even though we know at least anecdotally and maybe even more so that there's a very significant substance use problem among attorneys. So we've created that structure to be so constrictive in a way that you have like 30 people at a time, maybe 30 people a year in ADP, if that. It's probably less than that. So that's one downside.
Yeah, I think probably the small numbers have to, if it's a minor violation, I would imagine an attorney who's either dealing with a serious mental condition or serious drug or alcohol problem would rather take the discipline and not reveal the fact that they're suffering from this And if it's a more serious instance of misconduct, they're not going to be eligible to participate in the program anyway, because they likely would be facing, disbarment.
And Lee, I was going to say the one thing I think how we got the individuals that's a little bit different, because there's no, attorneys don't work in a hospital or any, firm that has to report anything like large firm or anything. But so we would have the hospitals, they would take action against the licensee, and then they were required to report that information to the board, which they would, and then we'd put them into the diversion program, because the only thing they were in trouble at the hospital for was for the substance abuse.
Okay.
Yeah. I think a lot, in fact, that was when we got rid of our program, that was the largest outcry, because they didn't really have, it was nice for them because they could refer them to the board and then get them into the program. It sounds like maybe we should mirror it almost what the attorneys have for a diversion program, though, it sounds like. One thing that changed with our boards and bureaus on the public side of this is that we, in 2010-ish, I think it was, we got legislation that said we had to have uniform standards for our substance abusing licensees. And so those individuals, there were 16 of them that have to be followed by the boards and bureaus. And one of those is that if they have any type of a restriction on them, so like for our licensees, like some of our allied health and some of those any of those individuals that had, like, you can only work 20 hours a week, or you could do, or you couldn't practice for these 6 months. The requirement was, like, if there was a restriction on their license, that had to be listed on the website, though it, you wouldn't say why if they were only in a diversion program for, on a confidential manner. Obviously, if they're in, because we would have allowed, and the boards do this, like they may have to go into this program as well as part of discipline. So it's a substance abusing licensee who also had, something else. So they get disciplined, they're on probation, but they're also in this monitoring program. Those obviously would be public because they're part of the disciplinary action. So really, we would only be talking about those that went involuntarily into a program or in lieu of discipline.
And now that you mentioned that, Kim, actually, I mean, that is a common condition of probation. Usually these cases come to the state bar and the court through DUI convictions of attorneys, especially repeated DUI convictions. So it becomes a criminal conviction referral matter for the, and a common condition of probation, because there's usually always some level of probation attached to discipline, is that they participate in an alcohol and drug abstinence program like AA or something similar to that, and provide certification of their participation. And there may be some drug testing involved if that's appropriate.
But they don't have to go in your program that you all have.
No, they can choose, but it has to qualify as an abstinence program. And I can't remember what it's in the standards of attorney sanctions, but, and they have to provide to the probation department proof that they're participating.
So based on this conversation, my takeaway is no agreements in lieu of discipline. Diversion, where are you with diversion?
I'd like to have it for some carefully defined, very low level. I'd like to have it for some carefully defined, very low level violations. For instance, a trust account violation, no more than $100.
And maybe you should separate, though, diversion for drugs and alcohol abuse versus practice issues.
Are there going to be trust accounts that the paraprofessionals are going to be handling?
We're talking about in the regulation group right now.
Different group.
Yeah.
I mean, I can't imagine that there wouldn't have to be client trust account because they're going to be taking advance. There's been talk of them at taking advance fees, which they shouldn't be commingling in their operating accounts. So that means they would have to maintain some form of trust account.
Yeah, they might take a deposit for costs, for instance, filing.
Yeah.
I mean, if the program, and this is, Julie's gonna smile, I know. If the program is protecting the public and the individuals are getting the help that they need, and that was the only issue, and you had a program, and maybe that's where Julie said, maybe we need to wait and hear what the program is and how they do it. I mean, I think there is a value, back to what Leah was talking about, you know, trying to help individuals recover or rehabilitate and the whole world around that. I mean, I think that there is some value to it.
The one thing I'll mention, because I just alluded to, you know, the ADP program for lawyers with drug or alcohol or mental illness issues that they can link to their misconduct, that is being referred to what they refer to as an ADP judge in the state bar court, and we have established a disciplinary system that doesn't involve the state bar court. So the question is whether or not, you know, either your staff adjudicators or your 3-person panel is really going to be able to adjudicate those types of issues, or whether or not we do actually need to loop in the state bar court for those types of cases if you're going to try to replicate what the system for attorneys. I wonder if it's helpful to have one of these ADP judges come and talk to you guys.
Greg, when you say ADP, do you mean agreements in lieu of discipline?
No, I'm sorry. It might be, no, I'm talking about
okay.
the
Alternate discipline. I forgot
alternate
what
discipline program.
yeah. I mean, at least
Agreements in lieu of discipline is ALD.
Yeah, I know.
It's hard to keep them straight sometimes.
when I was there wasn't, like, the whole idea behind having an ADP judge and setting it up is if it was going to be run like a drug court model, right? Because in drug court, these people come to court more frequently. There's this whole relationship between the court and the treatment provider and the defendant or the respondent, but it was not being run that way at all. There wasn't like training, or there wasn't. And maybe that's changed now. That would be, to me, if it was happening that way in state bar court, that would be an argument for sending the paraprofessionals, the small number of paraprofessionals that are going to fall in this category, sending them through the state bar court process, because it would be set up with this kind of drug court-like infrastructure. But it wasn't before. It might be now, which is my long way of saying, I think the staff adjudicator could be someone who would be trained, you know, we could train that person to kind of apply similar principles if we wanted to, as opposed to sending them through state bar court. But maybe things have changed there. I don't know. But it does sound like it
was talking about, that's slightly different, a diversion for not misconduct related to mental health or drug or alcohol issues. And the only way I just see that usually as a condition of probation, that they either participate in a client trust school or
well, right now we do it in these agreements in lieu of discipline.
and that's true, yeah, in the agreements in lieu of discipline, that's right.
Are those public?
No. And I was asking.
But one thing I'll add about that, we do have a separate rule of professional conduct that failure to comply with those agreements is a separate violation of the rules. It can be its own source of misconduct. So if somebody, you know, enters into an agreement in lieu of discipline, it's not considered discipline. But if they don't participate in the program or they violate the agreement in some way, that initiates a new disciplinary proceeding based on a violation of that rule.
That probably will be carried into the paraprofessional program.
That's a question mark for the regulation subcommittee.
Yeah, it is. But I think haven't they decided to make the rules of professional conduct applicable to the extent they make any sense?
Well, we're just to kind of reveal what they're doing right now, and we're doing on a staff level, is that I've been working with the Office of Professional Competence at the State Bar, just to go through the existing rules of professional conduct for attorneys and identify, the rules that we probably can simply replace lawyer with paraprofessional, like the duty of diligence or duty of competence. And then other rules that we need to decide, we need to have a better sense of what the scope of practice is going to be to see whether or not certain rules really would even apply. So for instance, there's a rule pertaining to clients as organizations, Rule 1.13. We're not even sure we're going to allow paraprofessionals to represent entities as opposed to persons. So that rule may not even be necessary, but it may be. And then there's other rules that really at bottom, there's some foundational policy considerations that the working group need to consider, like true referral fees, whether or not paraprofessionals are going to be allowed to give referral fees to each other, and a slew of other rules. So we've been basically going through all the rules, identifying these policy issues and trying to tee them up for the regulation subcommittee so they can wrestle with the policy considerations and then understand, based on what they decide, how that reverberates through the existing rules and how they may be different. Because I don't think we can simply take the rules we have and replace the word lawyer with paraprofessional or whatever we're going to call these individuals. It's just not going to work that way, because we're talking about very limited practice that we're going to allow these professionals to participate in. So some rules just will have no applicability or just will not make sense. And then other rules, depending on decisions that we make, we may necessitate revisions to the rules of professional conduct for lawyers. And so we're just identifying those as well, to the extent they're going to be allowed to practice with paraprofessionals.
Can I ask a question about the agreements in lieu of discipline? Maybe this would help make some decisions. So anybody that knows how this is decided, like who's the decision maker, A, and what are the factors that you look at when you decide whether I'm going to go for an agreement in lieu of discipline or I'm going to go file a public reproval against this individual? What's the criterion? Is it, something that can be done equitably?
I don't know. And I think we can make sure to bring somebody forward who does.
Okay, that'd be really helpful.
I believe there is kind of a cost benefit analysis of how costly from a labor perspective it is to take cases through the disciplinary process versus handling them this way. I do think that's one element of it. But I think, Ira, to get at what your goal is, we would need to retain that. That's the easiest vehicle to retain that, as opposed to calling it something new under diversion.
Retain
the ability to kind of deal with minor violations, even if they could be they are disciplinable violations, but we're going to have the ability in our system to deal with them differently. I think agreement in lieu of discipline is probably the way to do that.
Okay.
Yeah, I'm just making sure I understand. I know that an agreement in lieu of discipline is negotiated between OCTC and the respondent or respondent's counsel. I believe it has to be approved, though, by the State Bar Court, because usually there's already been charges filed.
That's very similar to diversion. The way I think of diversion. So it seems fine with me to use that system, agreement in lieu of discipline, since the State Bar is familiar with it.
So Greg, you said it's after charges are filed. So are your charging documents not public information?
They are.
They are.
So you file that, then it goes to this agreement in lieu of discipline, and then everything comes off public record?
Well, I don't know what happens in that instance, because the charges are appearing on their attorney profile, and I think if they that's a good question. I need to figure that out, whether or not the charging document is removed from their public profile on the website.
Interesting.
And Greg, did you say earlier that agreements in lieu of discipline are not public? Or is that what you just said? You don't know?
I don't know. Well, the agreements themselves, I don't believe are public. But the question that Kim brought up, which is a good one, and I'm not sure what the answer is if an agreement is negotiated after charges have been filed, the charges
Yeah.
are already posted on their attorney profile.
Right.
So if they enter into an agreement and it's approved by the state bar court, are those charges removed from their profile? And I'm not sure what the answer to that is. Brady, do you
Okay.
have any sense of? No.
And
No.
I'm getting confused
I don't.
by
You can do it.
when the LAP program was created some 20 years ago. At that point, the bar adopted some regulations, I think approving something called Alternative Discipline Program, ADP, or was that the agreements in lieu of discipline? I just can't remember. But the LAP was connected to one of those two.
ADP, that's what Greg was
ADP,
talking
yeah.
about earlier.
Okay,
That's our version of a drug court.
yes, okay.
Which I actually like. I mean, I think that's kind of a good thing. You have the person to go through and they identify whether they are even a good candidate for a program. I guess depending on who's sitting on it, but.
Yeah. So I feel like what we need to do, we obviously need to get a lot more information about how the agreements in lieu of discipline, how that process works. So we'll get somebody from OCTC for sure to educate us on that. Because
Okay.
I did not think, Greg, that NDCs were filed there. So maybe, so obviously more information would be good.
Yeah, that would be. good
So,
to know.
so we'll get that, and then we can get more information about the ADB program. I can reach out to the State Bar Court, see who's, maybe they've got somebody,
One of their ADP judges.
yeah, one of their ADP judges that's really involved might be good to bring forward. So we're not quite ready to abandon the agreements in lieu of discipline. On diversion, substance related, we're thinking we're going to run this parallel to what's happening on the attorney's side. Okay. Good progress. Thanks, you guys. So we'll see you next week.
Thank you.
Okay,
Okay.
sounds good. Thank you.
Bye.
Bye.
Thank you.